Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. The real question today is, who let me buy that shirt? Can I sue them? It's hideous. Very comfortable though, downright fuzzy. I love the feel. It's just not, looks very strange on camera. All right, we have a question here from YouTube user Still Rising. And I'm going to cut out and paraphrase a bunch of stuff here because it was a long back and forth in the comment section, and I want to just get the core of the question onto the video because it's make it more concise, right? So Still Rising asked us, question: when a corporation finally decides to engage specialized employment defense counsel, does that mean they're taking a charge of discrimination seriously? They do have an arbitration clause on their side, and my attorney has not yet received any kind of settlement offer. Looks like they're slated to potentially proceed to forced arbitration on May 1st. Now, Still Rising goes on to say, I think that what stuck out to me the most was it appears the employer didn't take the charges seriously until I changed attorneys. Within a week of receiving a new demand letter, the corporation had outside counsel reach out to my attorney. Now, the employer has 13 days before he initiates the arbitration process. My charges were tied to a discriminatory termination, followed by blacklisting, being listed as ineligible for rehire, which I viewed as retaliation, even after one of the leaders of the company reached out to me to come back to employment in another capacity. And the question goes on, does defense counsel look into the reputation of the employee's attorney? Yes, absolutely. I can give you an example right off the bat. So I know most of the employment attorneys in New York City. I'm practicing there for a while now in this kind of small insular field. And, in-house counsel from large corporations who have worked with me for, over a decade now will call me up and will say, hey, I hope your client enjoyed that check last month, you jackass. And I'll say, I believe she did. Thank you very much. Thank you for the check. I think she was very happy. I think you made a wise decision not to, have this fight. And of course, defense counsel just doesn't want to hear that, doesn't care, and says, listen, all right, glad you like the check. Question for you. Got a demand letter from this attorney. Never heard of this person before. Here's what I know. Some prior ethical issues. Haven't dealt with them before, which is weird because I have a major multinational corporation. We do a lot of these. And I looked at the dockets. His firm has never filed a litigation on the federal docket in this field. Like never, not once. So what can you tell me? Should I be at all concerned about this guy, or is he a loser? And the answer to that, I'm going to answer honestly, right? If I can, and if I hopefully have the ability to truthfully answer and say, listen, that guy's a great litigator. That guy is going to give you the full court press, spend hundreds of hours, invest heavily in this case. You don't want this smoke. You better pay that guy's client. You don't want this. But often that's not what I get to say. Often, unfortunately, because I have to maintain these relationships for the good of my clients, I have to say things which are truthful, like, yeah, that guy has a gambling problem. And on Fridays and Saturdays, he gambles compulsively. And on Mondays, he pressures his clients to take junk money because he can't pay, his office rent. That happens, right? Or somebody calls you up, they say, hey, I never heard of this guy. I don't know anything about him. What's the story? Yeah, he's not going to do discovery. He's got a major coke problem. And spends most of his time getting retainers out of clients, and then runs out, doesn't do the work on the cases, and just everything goes up his nose. And then before he gets the malpractice claims, he settles the case for junk because he didn't do discovery, so he can't prove them. That's not fun. I don't like doing that. There's an employee on the other end of that jackass attorney who's not doing his job. But I got to be honest, because when I'm honest, my clients get much, much better deals. And my duty of loyalty is to my clients, right? First and foremost. But the point of the story is, yeah, they check up. Employment law is performative at all stages. You need to appear to be a detail-oriented, irrationally aggressive avatar of justice. That's the gig. And if everybody knows you're not, and if you attend mediation going, I think I need 20 minutes. I just need 20 minutes. Everyone's going to know you're a fucking joke. You're not going to do the work, that you lack the density of soul to properly go to war, and no one's going to give your clients the money they deserve. So yes, without question still rising, in-house counsel and defense attorneys will evaluate the representation a client has. They even do it. Listen, I know for a fact, people will say to me, like, listen, you don't take junk. This looks like junk. Why did you take this case? The defense attorney, I'm like, no, this is not junk. You're being lied to by your people. Like, literally, the people who hired you are feeding you a line of bullshit. And if you go to war on this, you're going to get fucked up. Because there's a lot of lies in what you're being fed. And you're going to walk into a buzzsaw with bad intel, right? And they'll look at you like, fine, I'm going to go back to my client and I'm going to truth check them because I don't want to get buzzed. I don't want to embarrass myself in federal court. I don't want this. I don't want that, right? They don't want to lose big. No one wants to be the defense attorney who gave up the massive verdict, right? It's part of the reason why they settle cases. It's good for their clients. It's also good for their career, right? They want to bill in the case and win, or they want to bill in the case and settle. What they don't want to do is bill a lot of money on a case and lose, because everybody knows. Everybody knows, and that's not good for business as a defense attorney, right? So when they know who they're dealing with, or they have good intel on who they're dealing with, it will sway them one way or another, right? I'm trying to think of an example. There's a number of attorneys on the East and West Coast that if they take a case, they're going to be doing the press on the case. They're going to be paying extravagantly for the finest expert witnesses. They're going to be pouring resources into the case. Like this, you're going to war. They wouldn't take the case if they weren't willing to try the case. And it's the real deal. And when you have a case against them, every decision you make is couched in that knowledge, right? When you take a case, or when you get a demand letter from a settlement artist that it gets his clients 15 to 20 grand in every case, you say things like, "You want 10 grand? I'll give you 10 grand. You want 10 grand? I'll give you 10 grand. You go away." Because there's a good chance. There's a good chance he might take it, right? That's got nothing to do with the strength of that case. It's got everything to do with what you know about that attorney and how that attorney might sell his or her client down the river for some easy money. There's also people, listen, there's PI firms. I've seen some PI firms recently that have tried to take employment law cases. So a couple of them are heavily advertising on podcasts these days. And to what extent do those firms actually know how to handle an employment law case? How many of their many attorneys are actually employment attorneys? A few, I'm sure. But what's their pedigree? And if you get a demand letter from a PI firm and you're an in-house counsel, you're going to say, why am I going to give these PI attorneys money? What do they know about employment law? Should I even take them seriously? What is their proof of concept? What makes me think that they can actually do a good job here, right? These are all valid questions that a defense attorney would ponder before making a settlement offer. So still rising, you're very perceptive. I hope this answers your question. If it does, like, subscribe, comment down below. If it doesn't, tell me how I fell short. I will track the comments. I will try to do better. I will try to give you more specificity or a better answer. I know my answer kind of wandered on this one. Remember, everybody works. Not everybody wins. And good luck at your arbitration if things go that way. Take care.